Hello, everybody. So it's about noon, so I think we're about ready to start. Thank you, everyone, for coming to the Hicks Thomas monthly CLE program. I'm Colin Watterson. I'm a partner here at the firm, and today I'm going to be talking about my favorite topic of late, which is AI. I'm the only presenter here because I will not shut up about this topic. Sort of the Cassandra at the firm when it comes to AI. So I've been really looking forward to this. I'm going to save a little bit of time at the end for questions. And then if you have something that comes up during the call, you can use the chat feature, and I will try to check on that as well. So without further ado, I will get into it. So the title of the presentation is ChatGPT Didn't Write This CLE, or did it? It did not, but I did have AI do all of the artwork in the slideshow. So all of the graphics and whatnot were created by Dolly, which is OpenAI's software that allows you to create images. I've also included the prompt that I used to create the image. So if you're curious about it, you can see what I entered and sort of what was returned. The agenda, we're going to go over a few different areas. The first topic, why you should care. This is sort of the scary part of the presentation. We will talk about whether AI will take your job. I don't think so, but others disagree. We'll talk a little bit about what AI is. I am not a computer scientist. I don't even play one in court, so I'm going to be careful not to get over my skis when we talk about the science piece of things. And then we're going to talk a little bit about some of the emerging legal issues. And then we're going to also talk about the ethical issues that I'm sure you guys have all heard about. Do not have AI write your brief for you without checking it. If you take nothing else away from this presentation, do take that away. Why should you care? I thought that this was sort of, I kept these slides because I tried to get Dolly to create a picture of an ostrich with its head in the sand. But as you can see, it got fairly close, but it didn't quite get it right. And I thought this is a pretty good sort of encapsulation of the state of AI as it exists now. It's interesting. It has a lot of promise, but it's maybe not quite ready for prime time just yet. In terms of why you should care as an attorney, in a lot of ways, AI is already here, is already a part of the legal profession. Thomson Reuters acquired a company called Casetext last year for $650 million. Casetext was sort of the first mover when it came to generative AI platforms, specifically for attorneys. Thomson Reuters is going to invest, they say, $100 million a year in additional AI development. Lexis has launched a competitor platform called Lexis Plus. Both of these services allow you to sort of ask legal research questions with natural language, phrasing a question the way you would to a friend or colleague, and then it allows you to it'll draft a sort of first cut of an email or a brief or a document. And then it can also summarize depositions or lengthy contracts, things like that. ChatGPT 4, the fourth version of OpenAI's model, has passed the bar exam. So The graph on the left shows this was a paper that was put together by a law professor and some computer science professors. So the bars on the left are in red. Those are the various models of these are sort of large language models that they tested with the 2022 bar exam. The green bar is GPT-4, and the blue bar is the average of the student test takers on the multi-state multiple choice portion of the bar exam. And so basically what this shows is that all of the previous versions of these large language models performed worse than student test takers, but GPT-4 actually performed better in the sense that it is scored better than the average test taker did. The folks who designed the study also had GPT-4 take the essay portions of the bar exam, and it candidly it did a lot worse on the essay portions, although it still passed. But for example, AI may be more like humans than you would think. There was a question about the rule against perpetuities on this particular version that apparently it did not do well on. And there were some other questions that it sort of missed the call of the question, and very similar to a real human bar taker, it did not get all of the questions correct, but you don't need to pass the bar exam, right? And so that was sort of one of the researchers' points is that right now it's at least comparable to a human test taker. This was the conclusion at the end, was that large language models can meet the standard applied to human lawyers in nearly all jurisdictions in the United States. Now, I think that's sort of a deliberately provocative conclusion to this article, but it does raise some real challenges that I think are going to be coming for the profession. This is an excerpt from a case from 2015 called Lola v. Skadden. Now, this case doesn't have anything to do directly with AI. It was about somebody who was a contract attorney doing e-discovery work who sued under the FLSA. But the sort of point that I wanted to make by just bringing this case up is that at the oral arguments in the Second Circuit, the parties ended up agreeing that somebody that did what had been thought of as legal work, but as they concluded it was not, just doing purely mechanistic tasks, something that could be done by a machine, would not be considered the practice of law. So this is before all of these generative AI tools, but these products are going to be able to do what folks think of as traditional legal work, whether you consider e-discovery legal work or not. The sort of core of it, writing arguments, doing legal research, that sort of thing is increasingly going to be something that can be done by machines. And so the degree to which that's going to affect ethical issues and then potentially legal ones, such as employment issues, those are all on the horizon. Goldman Sachs has estimated that the legal industry is one of the most subject to disruption of any of the industries in the United States. So this is estimating that 44% of legal services will be replaced by AI in the future. And so it's one of the most affected industries, at least according to this Goldman Sachs study. This is an article that was written about how AI has been used by Coca-Cola's legal department. And in the article, they cite what I think is sort of this incredible statistic that talks about their folks might have taken 10 hours reviewing a contract, and they've been able to take that time down to 15 minutes because of how they've been using AI tools. And the sort of conceit of the article is that this has really helped their practice. It's freed folks up to think of, work more on high-level strategic tasks as opposed to kind of the nitty-gritty of drafting. But it is sort of, I think, with the previous slide, it does show that a lot of time that we spend on traditional tasks could be taken and we made more efficient by AI. This was a notice that, alas, the malpractice insurer sent around last year. We're going to talk about a little more detail about citing AI-derived case law in your brief, but this notice came out after that incident. And so they're talking about some of the risks that come with using these tools: data privacy, hallucinations, and disclosure. We're going to talk about all of those throughout the rest of this presentation. Finally, it is your obligation. The disciplinary rules and your duty of competence requires you to be familiar with the technologies that are available to lawyers and their risks and benefits. And look, when we talk about the benefits of AI, I think that there is one that is clear and obvious and manifest. It is that this technology will help lawyers become more efficient. And I think that almost everything else, at least at this point, is sort of a downside and a risk of it. And so it's sort of up to us to understand, how will this efficiency that can come with this new technology, how will that help me as a lawyer and help my practice? But what do I need to know about the risks of that efficiency, and what kind of guardrails do I have to set up when I'm using it? And that's really going to be the focus of almost the rest of this CLE. The ABA also, this was a couple years ago, but they've adopted a resolution urging lawyers to become familiar with the use of AI in the practice of law. And we'll talk a little bit more about this in a little, but the Texas bar, as part of the way of dealing with AI, they are considering adding a technology CLE requirement. So it would be 1 hour of technology CLE in addition to your ethics CLE. And so this CLE would sort of be designed to address that requirement when or if it comes out. Okay, so let's talk a little bit about what AI is. This is a very commonly used definition. This is from the ABA's Resolution 112, but the capability of a machine to imitate intelligent human behavior. So that is a broad definition that does not just include these chatbots or sort of generative AI that we've all heard about recently. Even as lawyers, we have been using AI in the practice of law for some time now as part of electronic discovery. There are sort of ways that people, and one of the big differences was in these sort of previous versions of AI and e-discovery, you would have humans kind of teach the computer what to look for. The difference is now you don't have that sort of human component anymore. But you would have automatic translations of foreign language documents. There were sort of contract management or due diligence software for deals where they would use AI. And then some services offered natural language searches. That's the ability to ask a question phrased like you would to a colleague, as opposed to a Boolean search with an operator like an and or. And so, so what is generative AI? Generative AI refers to artificial intelligence that creates brand new content. And there's sort of two ways or two types. De novo refers to AI where you, usually with a written prompt, but the user enters some kind of prompt and then the AI returns text or an image, something like that. Ab initio is when you provide the AI with some type of content. And so that's what this is here. I gave the cartoonize yourself. This is something you can get on OpenAI, but it's a picture of me, and this is sort of the I'll say unrealistically flattering way that they translated myself into a cartoon. So, remember, AI is not realistic, everybody. You may have heard the term large language model. And so large language models, they refer to a specific type of artificial intelligence. Machine learning refers to the idea of a computer program that tries to learn without human input. So this, what I talked about a little earlier, the idea of kind of lawyers training e-discovery software, what types of documents to look for, that's sort of human influence training. Machine learning would try to have software do it all itself. And deep learning and neural networks are two similar concepts. Basically, deep learning is sort of a more it's a more sort of complicated version of a neural network. A neural network is a type of AI that tries to replicate the human mind. And this is where I need to be careful not to get over my skis too much, as I'm not a computer scientist. But the idea is, at a very high level, this in our brains, we have synapses that connect our neurons. And so what these computer models try to do is they try to take concepts and connect them to other concepts, sort of like the way that your neurons are connected by synapses. And the way that they do this is by analyzing huge volumes of data. And so in the example of OpenAI and ChatGPT, which is probably the most famous version of this, this program has been trained on substantial portions of all of the text that exists on the internet. So huge amounts of data. And after analyzing all of this data, the program is able to form sort of statistical connections between different concepts. And so a very basic example of this is the phrase, strike while the iron is hot. That phrase has probably been written on the internet, hundreds and thousands or tens of thousands of times. But on the internet, it's very large. Somebody has probably written strike while the iron is cold as well. And there's probably other variations of that too. And so in terms of what the AI does with this information is that when it sees the phrase strike while the iron is, it knows that most likely the next word that should come in the sequence is hot. And so that's what a large language model essentially does. It will guess what the next word that should come in a sequence is based on its training data and this statistical sampling that it's performed. And so this all sort of depends, and this is an important point, the training data will depend, or these connections that will be formed depend on the data that has been fed to the AI. So in my example of strike while the iron is hot, if for whatever reason your data had a lot of strike while the iron is cold, you would get different results. But sort of more realistically, what we as lawyers need to know about is that any kind of bias or inaccuracies that are in the training data will be translated over to the model itself. So this is a well-recognized issue with these platforms. But for example, bias, and we'll talk about that a little bit later. But because the data itself has biases in it, it'll be translated over to what you, the user, see and the results you get. There's also decisions by the developers of the AI tool that you need to consider. And so this, for example, you may have heard Google had an AI program that they launched fairly recently. And they did a lot of work to try to address bias that comes with these models. And so they did it sort of not on the training side, but kind of on the development side. And so what they would try to do is that if by default the AI would generate images that have a lot of pictures of men, for example, it would try to randomize the results to maybe make it a mix of men and women. But people sort of didn't like that either. And so Google's kind of reworking their model. So it's a difficult decision to deal with. But another example is that if you go onto ChatGPT and you try to search for case law or ask it to give you case law, it is going to warn you, and it's not going to give you case law anymore after these kind of well-publicized issues. So that's a decision that the developers made to stop ChatGPT from providing that kind of information. And so this is I don't know if computer science articles are ever really famous, but this is a fairly famous paper that was put out about large language models, and it has this famous description of them as a stochastic parrot. I had to look up what stochastic meant, but it means random. But it's a really good way to think about these tools, is that it is parroting the information that it's received from its training data, but it's not a human being. It's not even a parrot. It doesn't understand meaning at all. It's just making a guess about what it thinks based on its data should come next. So I think as lawyers, that's something really important for us to remember, because even though these things are programmed to speak to us like humans and they have this sort of uncanny valley aspect to them, they're not. They're machines that don't understand what they're saying, even if it may sound like they do. And then a final thing, term to be familiar with is hallucinations. And this refers to the tendency of large language models to essentially make things up, and when they do it, to do so in a way that sounds fairly confident. We're going to talk about the Mata v. Avianca case in a little bit, but I've kind of went into some detail just to show how confidently wrong ChatGPT was to this poor lawyer. And then I think one sort of technical aspect to think about, and why this technology, I believe, will be so disruptive to the legal practice, is just some specific things that we lawyers have done. We've sort of erected barriers into the practice by making it really complicated. We have all these words that mean one thing to normal people, but they have these specialized meanings to us, like security or tort, or we use strange words like indemnity. But we also have huge volumes of information that are freely available that can be used in training data. So briefs, we have judicial opinions, CLEs that folks put up on the internet, articles that you put on your website. All of that can be crawled by these AI companies, and they can use this information to help make fairly strong, accurate, robust models specific to the legal industry. So that is, I think a very good thing in terms of accuracy and efficiency in the future, but also a challenge to all of us as lawyers. So this is going to be a little bit of a change in topic. I'm going to do sort of a very high-level overview of some of the different legal issues that have arisen with AI. There are a multitude. And so this is just an issue spotter. If you have questions about specific cases or issues that we talk about here, I love talking about this stuff, and I'm happy to go into more detail, but this is going to be pretty high level. So first, ownership. This is something that has, at least in my assessment, has largely been corrected by almost all of the AI platforms. But when ChatGPT first came out, it was not, you, the user of the service, did not own the content that came back to you. So usually what these platforms, they'll refer to the input. That's what the user types in into the prompt, and then the output. That is whatever the AI tool delivers back to you. So a picture of me as a cartoon character, for example, that would be the output. So for a bit, OpenAI said that they owned the output. So that would be a big problem if you wanted to use it for anything commercial, essentially. So these are just some excerpts from terms of service from different AI platforms, and they all say that you will retain ownerships of the inputs and the outputs. which is a good thing. But if you are thinking about using an AI tool, this is something to think about, because if you do not own the inputs and the outputs, there are confidentiality issues, there are privacy issues, all of that that could come with basically giving data away to a tech company. So this is an important issue, although I think it's largely been addressed. Commercial use. This has also largely been addressed, although not uniformly. So, for example, I think so some of these AI tools, when you read the terms of service, they will say you can use the inputs or the outputs for any purpose. Others will say it's only for personal use. So if you are going to use AI-generated content for commercial purposes, you need to look into that. Now, one thing I will say is that most of these platforms, they offer sort of an enterprise product that's specifically designed for businesses. These issues have been thought of in those enterprise services generally. So this is more if you're just thinking about Googling something and using the kind of ChatGPT design for the general public. That's when this kind of issue may come up. So it's something to think about. Intellectual property. So this is my real conversation with ChatGPT. So I asked if it could draw an image of Snoopy from the cartoon Peanuts, and it told me no, because it can't create copyrighted images. Fair enough. So then I just asked it, can you draw a picture of a dog on top of a doghouse in the style of Charles M. Schulz? And so it gave me a sort of odd Snoopy that has an extra set of ears. But beyond that, it's pretty close. So to be clear, what I did is not allowed by basically any of the terms of services of any of these platforms. You are not allowed to use them to violate somebody else's copyrights. Now, I would say that this is all fair use because I'm trying to educate you good people. But this is something that is a huge issue with these platforms, because as we'll talk about in a little bit, there is at least a strong concern, or I'm not sure if there's evidence, but people think that you can use these platforms to generate copyrighted images or text or works. But before we talk about that, I just want to talk about generally about whether you can copyright something that has been created by AI. And the answer to that is no, you cannot. And that is because the Copyright Act has an authorship requirement. And there is actually some pre-existing case law that talks about how non-humans cannot be authors. So the Eurytania Foundation is a case where the parties, now they, both sides agreed, and it wasn't disputed, that there was a book that was authored by celestial beings. So in the Court of Appeals decision, there was dicta that strongly suggested that because of that fact, that the work shouldn't have been copyrightable anyways. They decided it on different grounds, but it's pretty strong dicta. And then Naruto v. Slater was the monkey selfie case. And so a naturalist, these are the monkey selfies on the right here, but a naturalist left his camera and the monkey took a selfie with it. And so he published it in a book. And so PETA sued on behalf of the crested macaque, whose name was Naruto, arguing that this naturalist had violated the monkey's copyright. And so you may be able to hear the laughs in here, but it was, as you might imagine, the Naruto lost that one. But so this has actually been addressed by the Copyright Office and in the district court. I think this was sort of the most interesting one, though. So this person created a graphic novel. And so she wrote all of the text herself. And she used a service called Midjourney to create all of the images. But then she cropped them and edited them and sort of arranged them herself. And so the Copyright Office concluded that the entire work was subject to copyright, It was her words were subject to copyright, her arrangement was subject to copyright, but the images themselves, because AI had created them, were not, because it wasn't a human author. And so that was, even though Midjourney, the way that it works is it'll create an image and you are allowed to sort of tweak the image by providing further prompts to the service. And so this person had done sort of hundreds of tweaks of all of the image in her graphic novel, but the Copyright Office still concluded not subject to copyright. This is a similar one. This was somebody that actually won a arts fair in Colorado. So the sort of original Midjourney image is the one that I'm showing on the kind of top left, and the one on the bottom right is what was actually submitted. And so here the author or the artist actually did some work on top of the image, but the Copyright Office concluded that this wasn't transformative enough to make the work subject to copyright. Very recently, there has been guidance from the PTO about AI-assisted inventions. And so basically, what the PTO says there is that a human needs to make a significant contribution to each claim in the patent. And they gave some examples of what would be insufficient. So sort of just coming up with a problem for AI to solve, just realizing that whatever it is the AI had created is an invention, or sort of just being open AI and coming up with a tool. None of those would be enough to get a patent, but you'd have to have a significant contribution as well. And then probably the sort of most famous or notorious lawsuits right now are the ones against the AI companies for actually copyright violations themselves. The New York Times has been, or the New York Times is suing OpenAI. There have been some sort of Hollywood folks. I think Sarah Silverman was one of the first people to file a lawsuit. And then GitHub, the website for coders, there's also a lawsuit against that. One thing that I will note is that Microsoft, if you are a subscriber to their enterprise tool, Microsoft will actually, they will indemnify and defend you for copyright claims that come out of using their generative AI tools. You have to implement certain sort of guardrails to reduce that. But to me at least, that is telling if Microsoft has this indemnification policy that people are at least concerned about it, and Microsoft at least believes it's enough of an issue that they want to provide it for their customers. And so this is a excerpt from the New York Times lawsuit. And so on the left, you have output from GPT-4, and on the right, you have the text from a New York Times story. And so, as you can see, it being ChatGPT, replicated a substantial portion of this story itself. This is referred to by the AI tools as memorization or regurgitation. And the AI companies consider this a bug. They do not want these platforms to be doing this kind of thing, but it happens. And so, this is a concern because this is pretty close to just straight up copying, or at least the New York Times would argue it. And so that's sort of, I think, the big part of what the copyright lawsuit comes from. Now, OpenAI, they disagree. Their position is that this is entirely fair use, and they actually have some decent authority on this. If y'all are familiar with Google Books, this was an effort to basically take millions of books, scan them, making copies of them, digitizing them, making them searchable. And in the case of Google Books, you can actually look up little excerpts from these books that have been digitized. Now, the ruling in those cases was that was a fair use. And so what OpenAI says is that by ingesting all of the New York Times works and so on and so forth. We're just doing the same thing. So that lawsuit, I think, is just at the motion to dismiss stage. So we're not going to get any answer about the fair use question, at least for some time now. And just briefly on the GitHub litigation, that one is a little bit different because it has to do with code. And so a lot of the code that's available on GitHub has open source licenses, and open source licenses will require attribution, notice of the copyright, and so on and so forth. And so the AI tools don't provide that information. So it's a little bit of a different case because of the open source license. Bias, we talked about this a little bit earlier. So this is, again, just I just asked ChatGPT to draw me a picture of a lawyer or paint me a picture of a lawyer. And these were just the first 8 examples that I got. And as you can see, it's all men and all white men, except for that drawing, I guess, in the bottom left. But again, it's sort of understand, AI is, take the bottom right picture. It's looking at generating an image of some lawyer in some church in Italy from the Renaissance period, it looks like. And so what do those paintings all look like? Well, it's a bunch of white guys, right? So that's why it's happening. But it's something that it's important to take into consideration when using these tools. And so there have actually been quite a number of lawsuits addressing these types of issues already. So Amazon developed an AI tool for hiring, and that was trained off of data from their previous 10 years of resumes. And so most of those hires were men. And so the AI tool, it turned out, would punish female applicants. So if somebody had something on the resume that said women's whatever organization, Women's Chess Club, for example, that applicant would be penalized. And there were also graduates from all women's colleges who were penalized. There was a lawsuit against iTutor Group. This was another algorithm that was used for hiring. And they discovered in that one, this is pretty straightforward and egregious, but it would automatically reject male applicants over 60 and female applicants over 55. And so there was another one, HireVue. This I don't think ever turned into litigation, but HireVue would do videotaped pre-screening interviews of potential candidates. And what they said is they were sort of analyzing your inflections and the way you spoke and your emotions and things like that. But the allegations were they were actually using facial recognition technology and sort of some of the we'll say biases that can come with people's faces and whatnot. And so HireVue has discontinued the use of this particular technology. Privacy, again, I will just talk about this at a very high level because there are a lot of issues. But privacy can be implicated if you provide an AI company with sensitive information or through whatever training data is used by the AI tool. Common law privacy torts can be implicated. There was a very recent lawsuit that was filed by the estate of George Carlin because somebody used an AI tool to basically recreate his voice and create some new jokes and kind of have some original George Carlin stand-up. There is a new Texas Data Privacy and Security Act that could be implicated by AI. There's federal, and then there's even international rules. The EU just passed a extensive regulation of AI. I'm not going to get into that, but there are specific privacy provisions in that law. So high level, there's a lot of potential issues with privacy and AI. Accuracy. So this is something that we're going to really dive into with the Avianca case, But if you go into the terms of service of all of these tools, they will disclaim the accuracy or reliability of their platforms. And so you need to be careful about using them. There was a fairly recent Canadian decision, and this will actually be my first of two Canadian court cases I will talk about. But this was a sort of Canadian small claims court case against Air Canada. And Air Canada had a customer service chatbot that was powered by AI. And so this customer asked whether there was a bereavement discount. And so the chatbot, what it did was it said that there was a bereavement discount and it was retroactive up to 90 days. But it also linked to the actual bereavement policy that Air Canada had published. And that actual policy says you need to buy the fare at the time of purchasing the ticket, or inform somebody that it's a bereavement fare at the time of purchasing. And so this person tried to get their fare retroactively reduced. They weren't allowed to, and they sued for negligent misrepresentation. And so in the Canadian court decision, the judge concluded that yes, there was evidence of negligent misrepresentation here, even though the correct bereavement policy was actually linked in the chatbot answer. So, I mean, that's just a simple example of how even, I think, fairly minor inaccuracies could create liability. And I believe Air Canada has now disconnected their AI chatbot. These are just a few other examples. There was in Arkansas, this is a sort of more of a government services case, but they had a program for providing home health workers, and previously a registered nurse would determine how many hours of home health care somebody needed, and they replaced that with sort of an AI algorithm. And so the algorithm, perhaps unsurprisingly, reduced hours substantially. And the named plaintiffs were all people who had cerebral palsy and some really serious disabilities. And so the kind of reductions, especially for them, were really, really egregious. And so the policy was sort of revised after an injunction was entered. But there have been other cases where there's been lawsuits against insurers for using AI to wrongfully deny claims. There have been wrongful facial recognition lawsuits. I think there's a fairly recent one filed in Harris County about somebody who was in another part of the country at the time, but was wrongfully accused of some kind of serious crime based on facial recognition technology. And then Tesla is being sued for self-driving car mishaps. So there's a lot of kind of different contexts for inaccurate AI leading to litigation. And so this is sort of on that note. This is probably if you've heard about AI in the legal profession, this is the case that you've probably heard about. It's the ChatGPT brief guy. And I talk about this in some detail, not to kind of poke fun at this lawyer or anything like that, because I actually think what happened is sort of understandable. But I think it's just a good cautionary tale for all of us to learn from this person's mistake and take this stuff really seriously. So just the underlying case, it was somebody who was hurt on an international flight. I did not know this, but there is a treaty that governs injuries on international flights called the Montreal Convention. And so the airline files a motion to dismiss because there's a 1-year statute of limitation. And so the lawyers for the plaintiff file a response and cite some case law in it that was generated by AI. So this is a little excerpt of one of the case citations. This is another one. And just at the bottom, the lawyer, no favors, signed it under penalty of perjury. When you sign a paper, you're still saying that everything is true and correct, but doing it under perjury probably wasn't the best decision. In the reply brief, the defendants, I think, were very understated, but they basically said, well, I was unable to find any copies of the case law that was cited, or it doesn't stand for the proposition cited. So the court issued an order requiring the plaintiff's lawyers to attach copies of the cases. So the lawyer did so. And I just wanted to I included some of these excerpts just because it's worth looking at the details a little bit. So this was supposedly an 11th Circuit case called Varghese. But if you notice, the panel supposedly includes Judge Higginbotham, who's a Fifth Circuit judge. He talks about a wrongful death claim. But as you go on into the decision, it talks about how this person was forced to miss their connecting flight and had to purchase new tickets and incur these additional expenses. So sort of doesn't quite make sense there. And then there's a discussion about how Varghese failed to exhaust his administrative remedies with the Chinese aviation authorities, and then that China Southern filed for bankruptcy in China, which triggered an automatic stay of all proceedings against it. Now, I have no idea whether you have to exhaust your administrative remedies with the Chinese aviation authorities or whether Chinese bankruptcy law has an automatic stay, but I doubt it. I think that if the lawyer had sort of closely read these cases, there are some pretty serious red flags that jump out at you when you read this stuff. This is a sort of different fake case, but it's a similar example. This was supposedly an Illinois case that was appealed up to the Intermediate Court of Appeals, but it was over refusal of the airline to allow him to occupy an exit row seat, which is very annoying. I hate it when that happens to me, but probably something you wouldn't take up to the Intermediate Court of Appeals. And so this is a little excerpt from the court's sanctioned order, and it talks about how the decisions share some of the traits with judicial decisions that are sort of superficially consistent, but when you go into the details, it's sort of just babble. And that's a way that these large language models have been described as having coherent nonsense. It looks authoritative. It looks like the model knows what it's talking about. It seems confident, but it really isn't. And so the lawyer actually included his full history with ChatGPT. And so he actually asked, is Varghese a real case? And ChatGPT said, yes, it was. This is another message that it sent because the lawyer did, some actual digging and pushed on it a little bit. This one says, they are real cases and you can find them on Westlaw and LexisNexis. And it's sort of, again, it emphasizes that you can find these cases in reputable legal databases such as Lexis and Westlaw. Again, that was not true, to be clear, that what OpenAI was saying is not accurate at all, but it said it in a very confident sounding way. The other thing that I just wanted to highlight is that when you look at the full chat history, really OpenAI gave this lawyer kind of a mix of information. With some of the sort of high-level discussions, this is a question the lawyer asked about general federal case law supporting a motion to dismiss. This fairly accurately describes the Supreme Court decisions in Iqbal and Twombly. And so this is actually fairly accurate and provides some pretty good information about some relatively basic case law. The problem gets to be where you sort of get into the details. And really what this lawyer wanted to argue was that a bankruptcy told the statute of limitations. And so it was sort of when you got into that level of specificity, that's when you started coming up with some problems. So this is, I think, maybe the most, I thought, egregious example. There is a real U.S. Supreme Court decision about the Montreal Convention called Zeikerman v. Korean Airlines. But what OpenAI did here is it came up with what it called an 11th Circuit decision of the same name, approximately a dozen years later. But both cases, both the real and the fake, were about the Montreal Convention, and both were a wrongful death case. The difference was in the real Supreme Court case, there wasn't a bankruptcy stay issue. And so what ChatGPT did was added in that piece of it to this discussion of the case law. So it's sort of a real mix. There are some real cases that are accurately described. There are real cases that are inaccurately described. And then there are some cases that are just made up out of whole cloth. So sort of a real kind of mixed minefield to go through. And so that is sort of a natural, I think, transition to the ethical issues that come with using AI in your practice. I did not talk about the legal issues that come with sort of confidentiality and proprietary information. But at least in my view, this is the number one biggest concern that we as lawyers have with potentially using AI tools, is the risk that we could potentially expose confidential information. And so I've sort of excerpted here some of the terms of service and the confidentiality provisions that talk about what these AI tools will do with the inputs and the outputs that you provide to them. And so now, they do not say that they will use your outputs for advertising or something like that. They will often even say that we won't use them for training our tools, so we won't use them as the new corpus that the model will be trained off of. But they do talk about improving their services and things like that. And so it is not entirely clear to me what that means. And so especially when we're talking about putting potentially sensitive information about our clients out there, I think that it's a real slippery slope, and it's really important to look at what these terms of service say. Now, there are tools that are specifically meant for lawyers that will have encryption and that will have thought of and addressed these issues. That again is sort of, from my perspective, less of an issue. If you're going to Lexis, they have looked into these issues and they have thought about them. But it's more a concern of if you are just opening up Google and firing up ChatGPT, where you need to think about this type of thing. And again, the sort of enterprise versions of these services, they are also better about confidentiality issues as well. But these are questions that you should think about asking before you use an AI model. How are the inputs and outputs used? And especially, are they used to train the model? We looked at the regurgitation issue that the New York Times is suing over. Imagine the situation where you provide some kind of sensitive information about your client, and then a few years later, it turns out that some AI model can regurgitate and spit that data out. That would not be a good thing. So it's really important to find out whether there's any training that's done. To what extent does the AI developer retain a license to use any of the inputs and outputs, and what can they do with that license? How do they store the data? How long do they store it? For example, GitHub, which is designed for coders and probably has a little more thought dealt to sort of proprietary information, they, I think, immediately delete your inputs and outputs on their end of the server. So that probably provides a little more protection than some of these other models do. The State Bar of Texas has emphasized this. This is, probably one of their biggest focuses as well. But confidentiality is a significant issue. Also important, your duty of competence. We have an obligation to competently represent our clients, and that includes using the tools that are available to competently represent our clients. And so we have a basic duty to understand these tools, how they work, and their risks and benefits. And so I'm hopeful that this presentation is giving you guys some of the background to do that. But I think it's also important to take away from this the idea that at some point we may have an obligation not to refrain from using AI, but to actually use it in our practice. And so this is what the ABA has discussed in their Resolution 112. They have said that there's been no cases or anything like that so far where the standard of care has involved using AI, but they sort of talked about how they can sort of foresee a world where it could progress to that point where AI tools become efficient and accurate enough that it's sort of our duty to use AI to kind of do the first cut as opposed to a human being. So I don't think we're anywhere close to that universe yet, but it's sort of the opposite problem than what I had thought about. The state bar talks about this too. And their view is that this is going to be much like Westlaw and Lexis became ubiquitous for legal research databases. It's kind of an AI that's going to do the first cut of a lot of your work is going to be ubiquitous in a few years as well. So again, to be confident in using these tools, we need to understand the risks and benefits. And then it's also important to think about the nature of the matter. If you have a smaller matter, it may be more appropriate to rely on an AI tool than a larger one, or one where there is a clear legal answer. You're just looking for the standard from Iqbal and Twombly. It may be more appropriate to rely more heavily on AI than doing your own research. So it's really going to depend there. Communication. You need to communicate to the client if you are going to be using an AI tool so the client can consider the risks and benefits themselves. The client will be more cognizant of potential sensitive information or confidentiality. And so whether this should be provided to an AI service. Again, the ABA mentioned this, which I had not thought of, but their their view and something to think about is when is it appropriate to communicate to the client a decision not to use AI? Again, I think that is sort of in a world where these tools become better and more efficient in the future. But that is something the ABA is thinking about, and so something that we should all start thinking about as well. And then, if you're an in-house counsel, are outside counsel using AI tools? That's something that you should ask about as well. Fees. We have an obligation not to charge illegal or unconscionable fees. And so this will feature my second Canadian decision. But this case, and I'll be it briefly, there is actually a decision that talks about attorney's fees. And the judge concluded that this lawyer tried to have a $900 legal research charge for preparing for a hearing as opposed to preparing the written motion or brief. And so the judge basically said, well, that $900 of legal research, that goes too far. But if you had used AI, you may not have needed to incur all of those fees. Now, Canadian court, whether that's right or wrong or your thoughts on it, this argument will be coming. If you are trying to get attorney's fees in any kind of case, but a class action, something like that, people will be facing an argument that legal research should have been done by AI. I am very confident about that. And then finally, the duty to supervise. As lawyers, we have a duty to supervise staff. And then, at least under the ABA rules, there has been a sort of a change to the rule to make it clear that it applies to non-human assistants. And so there is, for example, a lawsuit against a company called Do Not Pay, which bills itself as the world's first robot lawyer. It's debatable, but there's instances where this company it failed to respond to summons, or it admitted liability rather than denying it. So some pretty substantial mistakes, and so they are being sued because humans allegedly were not supervising this AI tool and allowed it to make what would be apparently some pretty big mistakes. So You may have also heard there are some courts in the wake of some of these decisions that have required disclosures of any AI-generated information. The State Bar of Texas says that these requirements are not very useful because both Thomson Reuters and Lexis have AI tools built in. So at this point, a lot of lawyer-created information is going to have some degree of AI generated information, and that we already have rules that say we can't sign a pleading without reviewing it and making sure it's accurate. And so I'll just end briefly on some of the ABA recommendations. One of they're focused on bias. We've touched on that. They also talk about transparency. This is the idea that you should be able to go back and audit AI. So sort of like we looked at like the chat history in the Mata v. Avianca case, there should be a way to go back and find out how did the AI create what it did. And so you can find out if something does go wrong, what happened. The idea that, and this is, I think, fairly obvious, but the AI should make the world a better place. It should be more helpful than it is harmful. And it should take into consideration different constituencies. So, in my mind, that's sort of plaintiffs and defendants. Let's not make something that's helpful for just one side. And so I think with that, I am.
You have a question in the chat?
Let me go ahead and do that. Yeah, so I am basically about done. Okay. Well, no questions, but I'm basically done. Let me get to the most important part, your course number. But I very much appreciate everyone's time. And we're right at 1 p.m. So we're done here, but if anyone has questions, I'm happy to take them, or feel free to shoot me an email, give me a call. I love talking about this stuff. So thank you very much, everyone.